tell you about a 28-year-old Noongar man who pretended to be armed to steal $20 and a necklace. He was convicted of that crime and sent to prison. He served his entire sentence without clemency. When he was released, he was slapped with a restriction order under the West Australian High Risk Serious Offenders Act. That law allows the WA government to continue to punish an individual after they're released from prison. Well, that's exactly what happened to Mr. Garlett, who was challenging that restriction in the High Court of Australia. Under his restriction order, Mr. Garlett is subject to 24-hour monitoring, ongoing curfews, travel bans, and geographical limits. And that's after he served his sentence. In the past, harsh restrictions on personal liberty in the community have only been approved by the High Court in cases of extreme risk. But because there's no evidence that Mr. Garlett poses a serious risk to the community, his lawyers argue that the High Risk Serious Offenders Act 2020 has gone too far. The National Justice Project has intervened by making written submissions to the High Court supporting Mr. Garlett on behalf of another Aboriginal man who is seeking similar restrictions. We argue that the WA High Risk Offenders Act is unconstitutional and discriminatory, as it actually functions as a means to punish First Nations people who are targeted by police and overrepresented in the criminal justice system, even after they've served their sentences. This is an important case for two reasons. Firstly, if the state of WA is successful, it will extend the power of politicians to restrict individual liberties when no crime has been committed, and it will allow the ongoing targeting of First Nations people. As a society, we have a duty to support individuals who have done their time in order to help them integrate back into society. We do not need more laws allowing for First Nations people to be detained on an arbitrary basis.